This is the Water Quality Association podcast.
Focus on the economics of the transaction. That begins with price, but payment terms are the hidden gem in all of that. Do I pay in 30 days? Do I pay in 60 days? Do I pay immediately upon delivery?
That's WQA's Mike Sennett, Chief Legal Officer, and talking about the importance of understanding contract law. And welcome to the podcast from the Water Quality Association, the leading voice of the residential, commercial, and industrial water treatment industry. I'm Wes Bleed. Be sure to give us a thumbs up, comment, and subscribe to the podcast so you never miss a show. And we'd also love to have you watch our podcasts on YouTube. In this episode of the WQA Podcast, we're talking about contract law made simple with Mike Sennett, the Chief Legal Officer and General Counsel at WQA. You'll learn why it's critical to understand pricing terms and payment terms, how contract length and renewal clauses can impact your bottom line, and why a clear return policy can prevent some of the biggest headaches. Practical advice that every dealer needs to know. Plus, we'll have our WQA Tip. It's all coming up on the Water Quality Association podcast. Well, we're getting practical about contracts, and our guest is Mike Sennett, Chief Legal Officer and General Counsel at the WQA, Water Quality Association, retired partner from Jones Day Antitrust and Trade Regulation Group. And Mike, great to have you here. We're going to be talking about Contract Law 101 for dealers and how to work confidently with customer contracts and vendor contracts and the like. And Mike, I know you're presenting on this topic at the 2025 Mid-Year Leadership Conference. And so depending on when somebody is either watching or listening to this, they're either getting a preview or perhaps finding out what they missed by not attending the conference. But either way, it's great to have you on the program. And I just want to say welcome back to the WQA podcast. It's been a while.
Delighted to be here, Wes. I know you and I have done a couple of these before, and they've always been well received by our group. And here our dealers are very active in their educational efforts, and contracts is one that they do need to pay attention to in this day and age.
Exactly. And before we get started, interesting fact about Mike is that he has been a world traveler as part of his ongoing legal profession. And Mike, just maybe touch on some of the places you've been.
Oh, wow. Wes, my practice in Jones Day is an international law firm, meaning that has offices all over the world. So I've been everywhere from spending, quite a bit of time in places like India and China, Japan, and throughout Europe, largely in Brussels, where the European Union is located, just many, many areas. And even somewhere along the line, as at Jones Day, I was actually Water Quality Association's outside counsel, for many years, and I visited both the RAI for Aquatech Europe for WQA, and equally as interesting was China as we developed our representative office in China. So even the WQA has sent me interesting places.
So if you're interested in a tip or a place to see or a site to visit, Mike is your guy, right? So the next
exactly,
pull him aside and pick his brain. All right, Mike, contract law. When I hear contract law, I think of that movie, The Paper Chase. And wasn't contract law one of the foundational classes in that movie that they had to overcome and deal with? Professor, I think John Houseman was his name, the actor. So I hope you're not going to be quite as tough as John Houseman.
Well, he had a lot of hours to do that in. That was a full, I go week in and week out for that, and many hours. And that's really what it takes to get into the nitty gritty of contracts. So much of what we're going to do here is provide just some highlights, some sensitivities for our dealers to think about as they're approaching contracts, and how can they protect themselves without necessarily having all of that legal background.
Right. Okay. So let's start with question number one, what are the 5 clauses, and you might have a different number here, but that dealers have to understand before they want to sign anything?
I always say number one before you sign anything, and I would do that internally with our folks as well as with any dealer, anybody, is understand the pricing terms of a transaction. It might seem simple, if you're buying an item for X or Y, but pricing can tend to get very sophisticated in so many of the arrangements. It can be, and by price, I'm talking about all of the terms of price. That means discounts. That means payment terms. We spend an awful lot of time as we think through contract principles, and as I teach this to others and other new lawyers or not, I always say focus on the economics of the transaction. That begins with price, but payment terms are the hidden gem in all of that. Do I pay in 30 days? Do I pay in 60 days? Do I pay immediately upon delivery? How much? How much per unit? All of that. That would be, that's kind of term number one. Term number two, very important. Again, in many contracts, if it's a simple transaction, perhaps not, but I always have people focus on term and termination of agreements. And by term, I mean, how long are you undertaking an arrangement? Oftentimes, this is something that, dealers will overlook. They'll come, they'll look at something, they'll get a contract, you're going to supply, and it's a supply from a vendor. He will supply something for 3 years, a basic commodity. And why are you paying for it over 3 years? What'll happen was that vendor will then have an automatic ability after year one, let's say, to increase price. Have you limited that increase? What happens if you've signed a no outs 3-year contract, you're real happy with the first year price, second year comes back and that price is through the moon. And you have no recourse unless you've looked at that term. I always ask our people to pay, the utmost attention to term. Everything from delivery timing as well, making sure that your delivery terms, timing, when you're going to get something, how, and or if you're the one doing the delivery. Service and products are 2 different things. Keep those separate, keep those in mind from a delivery standpoint. The more sophisticated terms that, sometimes it takes me a bit to explain, but I will say they're also part of this grouping, which are warranty terms. What are you saying about the product you're delivering? What is the manufacturer saying about the product you're delivering? And the same way from your end, if you're buying something, what is the vendor saying to you about the product that's being delivered? Is it being warranted against defects and workmanship materials, etc.? What about labor with defects? Who pays for all that? Pay a lot of attention to that. It's your product expectations, both from your customers as well as your vendors, are an important part, and that comes out in the warranty terms. And the last one is it's the second one that I'll say is on the sophisticated end of it, and that's indemnification. That is how you protect yourself. That's making sure when you buy and resell a product, that product, something goes wrong with it, what have you, in the product itself, not in your installation or whatever. Are you indemnified? Has the manufacturer stepped forward and said, we're going to take care of you? What happens when the customer ends up with a much larger lawsuit than anything you've delivered, any work you put in, largely not because of your workmanship, but because of a product that's defective? Who pays for it? So indemnification, you want to be protected, not for your own misdeeds, if you will, or oops, I did something wrong, but for that which somebody else is responsible for. Make sure they are indeed responsible for it. So those are my key core terms.
Yeah. And I know that various contracts that you and I have dealt with regarding the marketing and communications department at WQA over the years, you were a stickler on terms in terms of the renewal policy. Was there a renewal policy, and did you want a renewal policy, and did you want to make sure that you don't have a renewal policy? Touch on that briefly.
Sure, and that is something that I was always very careful about, and I know, Wes, one of the questions that often comes up is, when do I need to go to a lawyer? When do I not need to go to a lawyer? I'm in-house. It's expensive. I don't want to. And what I would always tell people, within and without WQA is you look at what these auto renewal terms are. Look at what renewal terms are, and find your way of having what I would call termination for convenience. You can have a 3-year contract, but if you put a term in there that says, "But for my convenience or for yours," it's usually often mutual. I can terminate this contract on 30 days written notice, 60 days written notice, meaning that if you don't like the term, the price has gone, something's happened in the marketplace, you're unhappy, you don't have a good relationship with a vendor or it's somebody you're supplying to, you want to be able to say, okay, all bets are off, we're going to walk away from it and start again. It's called, it really is. It's called a termination for convenience, and it will override what usually happens in contracts, which is might be a 3-year term, but it can be terminated if there's breach by other party. Very difficult to prove breach, and it's a very unhappy circumstance. So I always say just put in termination for convenience, and that way you don't have to do a lot of thinking about it.
Yeah, that's great. All right. Should a dealer approach, or how should a dealer approach contracts with customers differently than vendors?
Well, it's in its own way, contracts with customers for dealers and in our business needs to be approached as both a product and a service agreement. And you need to make sure that you are not being so heavy-handed as you're doing this, that the customer isn't getting our full, if you will, code of ethics protection. You want to make sure that you're fair always as you do your terms. And what I mean by that is that as you're thinking through your pricing terms, that you're clear about it to a customer, that you're clear about what you can do from a delivery standpoint, that your pricing is just everything we've talked about here, that from your end of it, as you're going in, you are being very clear. There are some consumer protection laws and regulations out there that do set what you can do warranty-wise, do set what you can do with financing agreements, etc. But when you go through all of those sorts of undertakings, you want to have that be understandable to the customer, just like you want to understand it. And sometimes I will, you'll see some dealers, they'll show me something, and I will look at some provisions and say, what does this mean? And they'll, give me a blind look. Well, I don't know. I just, my lawyer put that in. If you don't understand it, please, your customer's not going to understand it. So when you do your own contracts, make sure you've followed all these rules and that you've gone through it so you are comfortable with it, that you're comfortable with what you are delivering to your customer.
Let's go back to some of these clauses and things that people have to make sure that they're either in or that they understand that they're in the contract. Delivery windows, acceptance criteria, returns, service levels, and so forth. Which of those prevent the most headaches if they're done correctly?
In my mind, having fair and understandable return terms will prevent the most headaches. At least the kinds of arguments. The other sorts of things, delivery windows, yes, all important, but that usually there's a lot of discussion that goes around that. At the end of the day, it really is an ability of either the customer or the dealer when it's in the role with the vendor, the ability to say no, thank you, and to have a fair return. And a fair return policy that says, I am finished, will prevent the most issues. If you do not, then there's, the constant argument that arrives from, you don't have a right to return, all sales final. Now, if you're giving, again, everything is a price term. As we go back to, kind of 101 again on pricing, you may have a term in there and say, well, at this price, this is a special price. I am not providing an ability to return this. It is, within, I might give you 2 weeks or 30 days, but, and I will under certain laws, certain state and other laws, there are requirements about your ability to cancel a contract as a customer and ability to to affect a return, but you, from a return policy standpoint, focus on that one. Understand what your expectations are on both ends, both when you're a recipient as well as when you are the deliverer.
We've got a lot of great dealers in the WQA, and many of them, they want to go over and beyond to serve the customer. But where do dealers go wrong when they perhaps get to the point of overpromising? Is that a problem?
Yeah, and most of the problems with overpromising derive from something of a hesitation or unwillingness to discuss routine maintenance and the fact that these are sophisticated products, many of them now with advanced electronics built in, all, just so much in them that things will go wrong. And the real key to a dealer is your follow-up, is your ability to not to overpromise that it's going to be, just error-free and everything's going to work perfectly forever, et cetera, et cetera. You have to be able to acknowledge that you are there, that you're going to do maintenance. So many of these products, and we even see that if you're familiar with the Healthy H2O Act circumstance that we have in, hopefully we're going to get that out shortly in Congress and get that moving along to a farm bill. But again, as we would talk about these issues nationally, we would always make sure that everyone understands that maintenance is as much in the delivery as the product itself. And that means being fair, candid, upfront that, yes, these are terrific products. Yes, they rarely do things go wrong with them, but there's no guarantees. Get away from the absolutes. Just like I say, product's never going to remove all of PFAS. It's going to reduce it. Anything that's bad in the water will get reduced. It's never eliminated. I will, look at that. I look at our, lab reports, everything else. Wow, that was terrific. It's some still there. And just remember that about what we're doing here is we're doing our very best to deliver something that is key, important, but things will happen. And please make sure that, the customer's aware that your phone's there, email, contact, follow-up, and maintenance.
And I'm hearing that the importance of customer service is involved here as well. And as well, as you pointed out earlier, the code of ethics, the
Yes.
WQA code of ethics, you want to operate within that and make sure that your business practices align with the Water Quality Association's code of ethics. If you haven't heard of that, if you're not a member and you're listening to this is another benefit of WQA. You get the legal advice of a Mike Sennett, like we're hearing right now, and you get the support in terms of a code of ethics that dealers adhere to, and that helps the industry to do much better in terms of these business practices that we're talking about. So, Mike, can you share an example, maybe from all of the years of experience you've had, where small wording, maybe some fine points, actually changed outcomes in terms of how things were handled?
Most of the time, the difficulties that arise because the ability within a contract to make a decision as to either its termination or some changes or whatever, you don't spell out whose responsibility it is. And by that, I mean, the phrase that I like to use and get people to use is in its sole discretion. The vendor, in its sole discretion, can terminate this agreement on 30 days' notice. The vendor, in its sole discretion, can substitute product A for product B if product B is no longer available. If you don't put that in its sole discretion, you say, I can do this, and then what happens is you end up with all these debates over whether you had an absolute right to do that, whether the other party had to agree to it, whether it's fair, whether the circumstances are as you say they are. So you use something that gives you as the one party that needs that absolute right to make a change in your sole discretion. So I like to see that in there. And that, does go along with my other comment before about, the clause for convenience. Let me terminate for convenience. Because, and what I'll say to somebody is they say, well, I like this vendor or I want to continue. I said, fine, you terminate the contract. And you've seen this, Wes. We've all seen this. Okay. Now you go back and, it's, we in Latin will say a tabula rasa, meaning it's a blank slate. I'm starting all over again. And then, negotiate the terms that you want. And doesn't mean you're walking away from somebody. It means that contract is no longer workable and you want to come up with a new one. That's okay. A lot of this is okay as long as you give yourself as a contracting party an ability to move on this. And
boy, that sounds like a very interesting topic in and of itself, is when to make that change or when to go to that route.
Good business, and these are all designed really from the business standpoint for a, WQA dealer not wanting to run out to a lawyer every 20 times or every 20 minutes with a question on anything. And so I will say, as a dealer, if you were to ask, when do you bring a lawyer in and when ought you not to, or when is it not cost effective? And I'm really big on cost effective decisions here because, this can get expensive. And so the real key is to begin with the lawyer to make sure that your, what I'll call a template, your core contracts, your core contracting approach, the kinds of agreements that you might be willing to look at day in and day out, to make sure that those are, that template has been reviewed. And once the lawyer says, okay, this is good, you'll make some adjustments to it as you go along. You now are in control of it. You've gone to the lawyer once. And, and then again, when you're dealing with vendors, how much is at issue? I actually always have a rule. Well, if it's less than X dollars or less than Y dollars, meaning that it's not material to your business, it's not going to hurt you if you're wrong, then you try to do it with these term provisions. I said, you just try to say, can I get out of this quickly if it doesn't work, or what happens if it all goes wrong? And so you do that. Make sure you've got insurance. And I know that we're going to have a whole session, probably following this one on contracts at the mid-year leadership conference. We're going to have a session on insurance because that's also backs all of this. It puts everything in perspective from what you can do. And I also will say that there's kind of another arena, and that is, our dealers are becoming increasingly sophisticated in small systems operations, which can be governmental contracts, sometimes non-governmental, but sophisticated contracts with engineering firms who live day in and day out with complex contracting practices. If there are a lot of dollars involved, it's important for you on those sorts of things to go get legal advice, because these are not easily done. They're risky, great rewards, but it's not something, you don't take your template that you've already done for a consumer and walk into a small systems environment and try to use it. Just doesn't work. We see this with engineering firms. Even the engineering industry itself has lots and lots of boilerplate contracts that are dozens of pages long. You're going to need some help there. And I would say that's one area. Don't do that. Don't do it yourself there.
Contract Law 101 with Professor Mike Sennett. It's been a pleasure, Mike. I feel a lot smarter already.
Thank you, Wes. It's always a good session here. And obviously our mid-year is, we're really looking forward to having some dialogue with the dealers on these issues.
All right, Mike. Thanks again. Appreciate it.
Thanks so much, Wes. Take care.
Our WQA tip: plan now for the WQA Mid-Year Leadership Conference, September 16th through the 18th, 2025, in Rosemont, Illinois, just outside Chicago. Connect with others in the water treatment industry to advance the betterment of water quality. Share best practices with colleagues, discover the latest trends, and share your insights so others can benefit. Plus, participate in fundraising events for the Water Quality Research Foundation. Head on over to WQA.org/MYLC to learn more and register. Thanks for joining us for the Water Quality Association podcast, bringing you the latest news and insights from the association, our members, and outside experts to help you better serve your customer and grow your business. Learn more about water and water filtration at our consumer website, betterwatertoday.org, and learn more about professional certification, product certification, and how you can become a WQA member at WQA.org. Until next time, this is Wes Bleed. So long from the Water Quality Association.